We
For
need to
most
resolve
people,
this
a house
now.
was
I
nothing more
followed the
than wood,
rules. These are
concrete,
mine.
glass, and a roof. For Daniel Carter, it represented 27 years of sacrifice. Every brick held a memory of overtime shifts. Every flower in the front yard had been planted by his late wife, Emily, whose dream had always been to create a peaceful place where their family could gather every holiday. Even after cancer took her away 5 years earlier, Daniel kept every corner of the property exactly as she had left it. The white roses still bloomed beneath the front window. The blue mailbox Emily had painted herself still stood proudly beside the driveway. The small wooden swing overlooking the backyard still creaked gently whenever the evening breeze swept across the neighborhood. The neighborhood itself had changed far more than Daniel ever imagined. When he first moved into Willow Creek Estates, it was a modest community filled with teachers, firefighters, mechanics, nurses, and retired veterans. Neighbors borrowed lawnmowers without paperwork, children rode bicycles until sunset, and holiday decorations remained standing long after the celebrations ended because nobody complained. Then came the new Homeowners Association. At first, the changes seemed harmless. Fresh landscaping appeared around the entrance. Decorative signs welcomed visitors, streetlights were upgraded, residents assumed the higher HOA fees were paying for genuine improvements. But slowly the atmosphere shifted. Friendly conversations became written warnings. Neighbors who once greeted each other with smiles now whispered about violations and fines. Lawns were measured. Mailboxes were inspected. Trash cans left visible for an extra hour resulted in penalties. The community no longer felt like a neighborhood, it felt like a place under constant surveillance. Daniel ignored most of it. He had never been interested in neighborhood politics. His mortgage had been paid off years ago, his property taxes were current, his yard was immaculate. He believed that as long as he respected his neighbors, no one would have reason to interfere with his home. He underestimated how quickly power could change ordinary people. The HOA board elected a new president named Victoria Hayes. Victoria was successful, polished, and endlessly ambitious. She had moved into the neighborhood only 18 months earlier, purchasing one of the largest homes at the entrance to Willow Creek Estates. Within weeks, she had joined the HOA committee. Within months, she had become vice president. Soon afterward, she won the presidency after promising to transform the community into one of the highest valued neighborhoods in the county. Property values became her favorite phrase. Everything was justified in the name of protecting property values. Restrictions multiplied. Garden decorations required approval. Fence colors were regulated. Window curtains visible from the street had to meet community standards. Residents were informed that any exterior modifications required written permission before construction. Many homeowners grumbled but complied. Daniel barely paid attention. His home had not changed in years. Until one spring morning. Heavy rain damaged the old wooden deck Emily had designed decades earlier. Several support beams had rotted beneath the surface, making it unsafe. Daniel hired licensed contractors to replace the damaged structure with a stronger composite deck that matched the home's appearance almost perfectly. He obtained city permits. He followed county building codes. The project improved safety while preserving the original design Emily loved. To Daniel, it was simply responsible home maintenance. To the HOA, it became an opportunity. 3 days after construction finished, a bright orange notice appeared taped to his front door. HOA violation. The document claimed the deck violated architectural guidelines because no HOA approval had been requested before construction. Daniel assumed the matter could be explained easily. Surely the permits from the city would settle everything. After all, he hadn't expanded the deck. He hadn't built anything extravagant. He had simply replaced dangerous wood with safer materials. Instead of understanding, another letter arrived. Then another. The first warned of possible fines. The second announced immediate daily penalties. The third demanded complete removal of the deck unless the HOA board granted retroactive approval. The amount shocked him. $200 per day. Daniel reread the number several times. Surely there had been some mistake. The deck itself had cost less than the fines accumulating every week. He gathered every document the contractors had provided. Inspection reports. Engineering certificates. City permits. Construction photographs. He carefully organized everything into a folder before attending the next HOA board meeting. He expected professionalism. Instead, he encountered something entirely different. Residents filled the clubhouse meeting room. Some sat quietly, avoiding eye contact. Others clutched violation letters similar to his. The atmosphere resembled a courtroom rather than a neighborhood meeting. Victoria sat confidently at the front beside the other board members. Stacks of paperwork surrounded her. Violation reports, fine schedules, architectural requests. The meeting moved quickly. One resident questioned parking restrictions. Request denied. Another asked why tree trimming requirements had changed. Request denied. A retired couple explained they needed extra time to repaint their fence after medical emergencies. Additional fines approved. Nobody seemed surprised. Fear had replaced participation. When Daniel's turn arrived, he calmly presented every permit issued by local authorities. He explained that the old deck had become structurally dangerous. Replacing it had protected both his family and neighboring properties. Everything had been inspected and approved by the city. He believed common sense would prevail. Instead, the board emphasized something entirely different. City approval, they insisted, did not replace HOA approval. Rules were rules. Failure to request permission beforehand represented a violation regardless of construction quality. Daniel listened patiently. He pointed out that no architectural changes had actually occurred. The new deck matched the previous design almost exactly. It even used similar colors. The board remained unmoved. Daily fines would continue until full compliance. Compliance meant one of two choices: remove the deck, or submit a retroactive architectural application carrying additional review fees while continuing to pay daily penalties during the review process. The process could take 90 days. Daniel left the meeting stunned. The numbers no longer made sense. At $200 per day, 90 days meant $18,000 before any decision was even made. No reasonable homeowner could afford that. Over the next several weeks, more letters appeared. Final notices, collection warnings, threats of legal action, interest charges, administrative processing fees. The balance climbed higher every time he opened his mailbox. Meanwhile, neighbors quietly began sharing similar stories. A widow fined because her grass grew too high while recovering from surgery. A disabled veteran ordered to remove an accessibility ramp until architectural approval could be granted. Parents penalized because children's basketball equipment remained visible overnight. Nobody wanted to challenge the board. Everyone feared becoming its next target. Daniel started researching HOA laws late into every evening. What he discovered surprised him. State laws protected property owners more than many residents realized. HOAs possessed authority, but not unlimited authority. Boards still had legal obligations. They had to act reasonably. They had to enforce rules consistently. They could not ignore due process. They could not selectively punish homeowners. The deeper Daniel researched, the more inconsistencies he uncovered. Public meeting records revealed approvals granted to several board members for projects almost identical to his own. Some approvals had even been issued after construction had already begun. Others appeared to have skipped required review periods entirely. One board member had installed a much larger deck only 6 months earlier without paying any penalties at all. The pattern disturbed him. Rules seemed flexible for those holding power, rigid for everyone else. Daniel began organizing every document, every violation notice, every dated photograph, every meeting minute, every county permit, every email, every invoice, every HOA guideline. What had started as a simple repair project was becoming something much larger. He wasn't just protecting a deck anymore. He was beginning to suspect that the HOA had crossed a legal line. As another certified letter arrived demanding immediate payment and threatening to place a lien against his fully paid home, Daniel looked across the backyard where Emily's roses continued blooming in peaceful silence. He made a quiet promise to the woman whose memory still filled every corner of the house. He would not surrender the home they had built together. And if the HOA believed an ordinary retired homeowner would simply pay thousands of dollars without a fight, they were about to discover they had chosen the wrong person to intimidate. The first phone call Daniel made the following morning would change everything, not only for himself, but for the entire neighborhood. The next morning, Daniel Carter sat at his kitchen table before sunrise. The same table where Emily had planned family dinners and holiday celebrations was now covered with neatly organized folders, printed emails, county permits, HOA bylaws, financial statements, and every violation notice he had received over the past 2 months. The certified letter threatening a lien rested on top. Daniel had spent years believing that honesty, patience, and common sense solved most problems. But after weeks of escalating fines and dismissive treatment, he realized something important. This was no longer about a deck. It was about power. And power, when left unchecked, often grew into something far more dangerous. His first phone call that morning was not to another HOA representative. It was to an attorney specializing in property rights and homeowner association disputes. Attorney Rebecca Lawson had spent nearly 20 years representing homeowners against abusive HOA boards. During their initial consultation, she listened carefully without interrupting. Daniel explained every step of the deck replacement, every permit, every meeting, every fine, and every response from the board. When he finally finished, Rebecca asked for one thing: documentation. Fortunately, Daniel had everything. Every letter had been scanned. Every photograph was dated. Every permit had official inspection records. Every board meeting agenda had been saved. The attorney smiled slightly as she reviewed the growing stack of evidence. Many homeowners arrived with emotions. Daniel had arrived with proof. That made all the difference. Rebecca explained that homeowner associations absolutely possessed the authority to establish architectural review procedures. However, that authority came with legal responsibilities. Rules had to be applied consistently. Boards had fiduciary duties. Selective enforcement could expose an HOA to serious legal liability. Abuse of authority could become far more expensive than simply approving a deck. Daniel listened carefully. For the first time in weeks, someone spoke about fairness rather than penalties. Rebecca suggested beginning with a formal records request. State law allowed homeowners to inspect many HOA documents, including meeting minutes, financial records, architectural approvals, and enforcement history. If Daniel's suspicion about inconsistent enforcement proved true, those records might reveal a much larger pattern. Within days, the request was delivered. The HOA board responded reluctantly. Some documents arrived quickly. Others were delayed. Several requests were denied outright with vague explanations. Rebecca immediately noticed another problem. The board appeared unusually reluctant to produce architectural approval files. That alone raised questions. Meanwhile, life inside Willow Creek Estates continued changing. Residents noticed Daniel's determination. Instead of quietly paying fines, he continued maintaining his property exactly as before. His lawn remained perfect. Flowers bloomed. The new deck looked beautiful. Nothing about his home resembled the image of a rule-breaking homeowner described in HOA letters. Gradually, neighbors began approaching him. Not publicly. Quietly. One retired teacher shared copies of warning notices she had received over flower pots that exceeded the approved number for her front porch. A young military family described being fined while the husband served overseas because holiday decorations remained displayed a few days too long. A disabled resident explained how repeated requests for accessibility modifications had been delayed for months while board members received almost immediate approvals for cosmetic renovations. Each story sounded different, yet they all shared the same pattern: strict enforcement for ordinary homeowners. Remarkable flexibility for board members and their close friends. Daniel never encouraged anyone to break the rules. Instead, he encouraged something much simpler. Keep records. Save every letter. Take photographs. Document every conversation. Facts mattered more than anger. Weeks later, the HOA finally released a large collection of requested records. Rebecca's office spent days reviewing hundreds of pages. The findings were startling. One board member had installed an oversized covered patio before receiving formal approval. The violation had been dismissed. Another had painted their home an unapproved color for nearly 6 months before submitting paperwork. No fines. A third board member had constructed an elaborate outdoor kitchen exceeding architectural limitations. The application was approved retroactively, without penalties. Meanwhile, Daniel faced nearly $20,000 in accumulated fines for replacing an unsafe deck with one nearly identical to the original. The inconsistency was impossible to ignore. Rebecca organized everything into comparison charts. Dates. Violations. Board members. Ordinary homeowners. Approval timelines. Fine amounts. The evidence painted a picture of selective enforcement. Exactly the kind of behavior courts often viewed unfavorably. Before filing a lawsuit, Rebecca recommended one final opportunity for the HOA to resolve the matter voluntarily. A formal legal demand letter was delivered to every board member. The letter requested immediate suspension of fines, removal of the violation, equal enforcement of architectural standards, reimbursement of attorney fees, and preservation of all HOA records related to enforcement decisions. The board had 14 days to respond. Victoria Hayes viewed the letter as a challenge rather than a warning. Instead of negotiating, the HOA doubled down. Another violation notice appeared. Then another. Administrative fees increased. Interest accumulated. The board authorized legal collection proceedings. A notice of intent to place a lien against Daniel's home was prepared. Victoria believed pressure produced obedience. She underestimated what pressure often produced instead. Evidence. News of the dispute quietly spread beyond Willow Creek Estates. A local neighborhood blog published an article discussing aggressive HOA enforcement. Without naming Daniel directly, the article questioned whether homeowner associations had begun exceeding their authority. The story attracted attention. Residents from nearby communities began sharing nearly identical experiences. Some had paid thousands in questionable fines. Others had abandoned improvement projects entirely because HOA approval processes had become unpredictable. The conversation was growing. Inside Willow Creek Estates, attendance at monthly board meetings nearly doubled. Residents who had remained silent for years now filled every available chair. Few spoke. Most simply watched. Victoria noticed the change. She responded by tightening meeting procedures. Public comments were shortened. Questions required advanced submission. Certain agenda items were moved into executive sessions closed to homeowners. Transparency slowly disappeared. But curiosity continued growing. One evening, Daniel walked through the neighborhood after watering Emily's roses. Several neighbors waved. Some thanked him quietly. Others simply nodded with expressions that said more than words ever could. For the first time, Daniel realized he was no longer fighting alone. His case had become symbolic. Many homeowners lacked the financial ability to challenge unfair treatment. Others feared retaliation. Daniel represented something larger than his own deck. He represented the possibility that ordinary homeowners could stand up to an organization that had forgotten whom it was supposed to serve. Exactly 14 days after the legal demand letter expired, Rebecca filed the lawsuit. The complaint alleged selective enforcement, breach of fiduciary duty, failure to follow governing documents, unreasonable fines, and violations of state homeowner association statutes. Attached to the filing were hundreds of pages of evidence. Permits, inspection reports, architectural comparisons, meeting minutes, violation histories, financial records, photographs. The lawsuit did not ask merely for Daniel's fines to disappear. It requested judicial review of the HOA's enforcement practices. If successful, the entire board's decision-making process could come under scrutiny. The legal filing became public record. Within 48 hours, local media noticed. A newspaper reporter contacted Rebecca's office requesting interviews. Another journalist began investigating HOA complaints filed throughout the county. Television stations started monitoring court developments. Victoria Hayes had expected one retired homeowner to quietly surrender. Instead, she found herself defending the entire HOA before lawyers, journalists, and an increasingly curious public. Still, she remained confident. At the next board meeting, she projected complete control. Board members insisted the lawsuit lacked merit. Residents were assured that HOA policies had always been applied fairly. They emphasized protecting community standards. They expressed confidence in victory. But confidence often looks strongest just before uncomfortable truths emerge. A week later, Rebecca received an anonymous package with no return address. Inside were copied emails, internal board communications, handwritten meeting notes, and financial spreadsheets that had never been included in the HOA's official records request. Someone inside the organization had decided to tell the truth. As Rebecca carefully examined the first page, she immediately realized the lawsuit had just entered an entirely different phase. What the anonymous whistleblower had revealed threatened not only the board's reputation, but its future. The anonymous package arrived without a return address, wrapped in plain brown paper with no indication of who had mailed it. At first glance, it appeared ordinary, but as attorney Rebecca Lawson carefully removed the documents one by one, she realized the contents were anything but ordinary. Unlike the official records the HOA had reluctantly produced, these documents were internal communications that homeowners had never been meant to see. There were private emails between board members, draft meeting minutes that differed from the versions distributed to residents, financial spreadsheets with handwritten notes, internal enforcement lists. Even more troubling were several printed email chains discussing specific homeowners by name. Daniel Carter's name appeared repeatedly. The language wasn't professional. It wasn't objective. It wasn't even neutral. The emails revealed discussions about making an example of certain residents who questioned HOA authority. One board member suggested that homeowners who challenged violations should receive maximum enforcement to discourage others from resisting. Another message described Daniel as too independent because he refused to apologize after replacing his deck. Rebecca immediately recognized the significance. These weren't simple policy discussions. They demonstrated intent. Instead of enforcing rules fairly, the board appeared to be targeting homeowners who questioned its decisions. She contacted Daniel immediately. The following afternoon, they spent hours reviewing every page together. Each new document painted a clearer picture. Victoria Hayes hadn't simply wanted compliance. She wanted control. The internal spreadsheets revealed another disturbing practice. Violation categories carried recommended fine amounts, but handwritten notes instructed inspectors to increase pressure if homeowner resists. Some residents received courtesy reminders. Others were fined immediately. No objective standard explained the difference. The board had quietly created two systems. One for favored homeowners, another for everyone else. Rebecca carefully cross-referenced the anonymous documents with the official HOA records. The inconsistencies were impossible to ignore. Entire discussions had been omitted from meeting minutes. Votes had been recorded differently than internal notes reflected. Several architectural approvals appeared to have been granted without the required number of board members present. Some approvals had never been formally voted on at all. The deeper they investigated, the more troubling the pattern became. Meanwhile, news of Daniel's lawsuit continued spreading. The local newspaper published a lengthy article examining growing concerns about aggressive HOA enforcement across the county. Although the article remained balanced, it highlighted Daniel's case as an example of homeowners questioning whether associations had exceeded their legal authority. Within days, television reporters began interviewing residents outside Willow Creek Estates. Homeowners who had remained silent for years suddenly found the courage to speak. Some described thousands of dollars in fines. Others shared stories of delayed approvals, inconsistent decisions, and intimidating collection letters. Several admitted they had simply paid penalties they believed were unfair because they couldn't afford legal representation. Daniel never sought publicity. He continued mowing his lawn every Saturday morning. He watered Emily's roses. He maintained his home exactly as he always had. But cameras occasionally appeared near the neighborhood entrance, reminding everyone that what had once been an internal dispute had become a matter of public interest. Inside the HOA board, pressure mounted. Attendance at meetings continued increasing. Residents who had never participated before now filled every available seat. Questions became more detailed. Requests for financial transparency multiplied. Several homeowners formally demanded independent audits. Victoria responded by insisting that the board had always acted responsibly. Yet behind closed doors, confidence began to crack. One board member quietly resigned, citing personal reasons. Another stopped attending meetings altogether. Committees struggled to maintain quorum. Rumors spread throughout the neighborhood. Some believed more resignations were coming. Others suspected someone inside the board had leaked the anonymous documents. No one knew for certain. The lawsuit entered the discovery phase. Both sides were now legally required to exchange evidence. Rebecca requested complete email archives, financial records, inspection reports, enforcement logs, contractor agreements, and communications between board members. The HOA's attorneys objected repeatedly. They argued that certain documents were privileged. Others they claimed no longer existed. Some emails had supposedly been deleted. Rebecca wasn't convinced. Modern electronic records rarely disappeared completely. The court wasn't convinced either. The judge ordered the HOA to preserve every available document and warned that destruction of evidence could result in severe legal consequences. That order changed everything. Professional forensic specialists were hired to recover electronic communications from archived servers and backup systems. Weeks later, another surprise emerged. Deleted emails began resurfacing. Many had been removed shortly after Daniel filed his records request. Some discussed architectural approvals. Others referenced enforcement strategies. A handful included conversations about keeping certain discussions off the official minutes. Every recovered email strengthened Daniel's case. Then came the financial review. Rebecca had initially focused on selective enforcement. Now another issue surfaced. The HOA's financial statements contained unexplained transfers between operating accounts. Administrative expenses had increased dramatically during Victoria's presidency. Consulting payments lacked detailed invoices. Legal expenses appeared unusually high despite relatively few lawsuits before Daniel's case. Several board-approved contracts had been awarded without competitive bidding. Nothing immediately proved criminal conduct. But the records raised enough questions to justify closer examination. Concern spread rapidly among homeowners. Many began wondering where their steadily increasing HOA dues had actually gone. A group of residents organized independently, calling themselves the Willow Creek Homeowners Committee. Their goal wasn't confrontation. It was transparency. They requested open financial meetings, independent accounting reviews, clear architectural standards, consistent enforcement. Most importantly, they wanted every homeowner treated equally. Membership grew every week. Families who had never attended HOA meetings before now volunteered to review bylaws, organize neighborhood updates, and educate residents about their rights. The atmosphere within Willow Creek estates slowly began changing. Fear was giving way to participation. Daniel found the transformation remarkable. For years, neighbors had quietly accepted decisions they believed were unfair. Now they were reading governing documents for themselves. They asked questions. They requested records. They participated. The neighborhood that had once felt divided was beginning to rediscover its sense of community. Victoria viewed these developments very differently. She interpreted growing homeowner involvement as organized opposition. Instead of seeking compromise, she became increasingly defensive. More legal bills were approved. Additional consultants were hired. Special meetings multiplied. The HOA's insurance carrier also became involved. After reviewing the allegations and evidence, insurance representatives reportedly expressed concern about potential exposure if selective enforcement could be proven in court. Settlement discussions quietly began. Rebecca informed Daniel that the HOA had shown interest in resolving the lawsuit privately. The proposed settlement included removal of his fines, cancellation of the lien proceedings, reimbursement for his legal expenses, and confidential resolution of the case. Many attorneys would have recommended accepting. Most homeowners simply wanted peace. Daniel thought carefully before answering. This fight had never been only about his deck. If the case disappeared quietly, nothing would change for everyone else. Future homeowners could face the same treatment. The same selective enforcement. The same intimidation. The same abuse of authority. After discussing every option with Rebecca, Daniel made his decision. He respectfully declined the confidential settlement. If an agreement was reached, he wanted meaningful reforms that benefited every homeowner in Willow Creek Estates. Transparency. Equal enforcement. Independent oversight. Fair elections. Financial accountability. Without those changes, the underlying problem would remain. News of the rejected settlement quickly reached the board. Victoria reportedly reacted with disbelief. She had expected Daniel to accept compensation and walk away. Instead, he had demonstrated something she had underestimated from the beginning. He wasn't seeking revenge. He was seeking justice. As preparations for trial accelerated, both sides finalized witness lists. Experts would testify. Board members would testify. Former residents would testify. Inspectors, contractors, accountants, and homeowners all prepared to take the stand. The courtroom battle was now inevitable. Then, just days before the trial was scheduled to begin, the judge issued an unexpected order that neither side had anticipated, an order that could determine the future of the entire HOA before a single witness ever testified. Just 5 days before the trial was scheduled to begin, the judge reviewed hundreds of pages of evidence submitted by both parties. The lawsuit had grown far beyond the original dispute over replacement deck. It now involved allegations of selective enforcement, missing records, inconsistent architectural approvals, questionable financial practices, and possible breaches of fiduciary duty by the HOA board. Rather than allowing the case to proceed immediately before a jury, the judge ordered both sides into a court-supervised mediation while simultaneously appointing an independent forensic accountant and governance specialist to examine the HOA's records. The order shocked everyone. Victoria Hayes had expected another routine legal proceeding where the HOA's attorneys would defend its authority. Instead, the court had made it clear that the evidence already presented raised serious concerns that deserved independent review. Over the next 6 weeks, investigators examined thousands of pages of documents. Bank statements were compared with board approvals. Architectural applications were matched against enforcement records. Meeting minutes were compared with archived email conversations. Financial transactions were traced one by one. Every major decision made during Victoria's presidency was carefully analyzed. The findings were impossible to dismiss. The investigators concluded that the HOA had not applied its rules consistently. Board members had repeatedly received favorable treatment while ordinary homeowners were subjected to stricter standards. Architectural guidelines had been enforced selectively. Several approvals bypassed required procedures. Meeting records failed to reflect important discussions. Financial oversight had become increasingly weak, allowing spending decisions that lacked proper documentation and competitive review. Although the investigation did not uncover evidence of criminal theft, it revealed a pattern of poor governance, favoritism, and abuse of discretionary authority. The report reached every homeowner in Willow Creek Estates. For many residents, it confirmed what they had quietly suspected for years. For others, it was the first time they truly understood how much influence a small group of people had exercised without meaningful accountability. The mediation resumed with an entirely different atmosphere. The HOA's insurance company, recognizing the growing legal risk, strongly encouraged settlement. Several remaining board members privately acknowledged that continuing the lawsuit would likely cost the association hundreds of thousands of dollars in legal fees, expert witnesses, and potential damages. Eventually, an agreement began to take shape. But Daniel remained firm. He repeated the same position he had held from the beginning. This could never be about one homeowner receiving compensation. The entire community deserved protection. After several long days of negotiations, a comprehensive settlement was reached. Every fine imposed against Daniel Carter was permanently canceled. The attempted lien against his home was withdrawn immediately. The HOA agreed to reimburse all of Daniel's attorney fees and litigation expenses. More importantly, sweeping reforms became legally binding. All architectural review decisions would now require written explanations supported by published standards. Violation notices would follow uniform enforcement procedures. Residents would receive reasonable opportunities to correct issues before monetary penalties were imposed. Board meetings would become more transparent, with complete minutes available to homeowners. Independent financial audits would be conducted annually. Competitive bidding would be required for major contracts. Homeowners would gain expanded access to association records. An ethics policy governing conflicts of interest became mandatory. Board member training on fiduciary responsibilities was also required before assuming office. Perhaps the most significant reform involved elections. A special election would be held under independent supervision. Every board position would become vacant, allowing homeowners to choose entirely new leadership. Victoria Hayes resigned before the election took place. She issued a brief written statement citing personal reasons and a desire to move forward with her family. No dramatic speeches followed. No public confrontation occurred. The facts had spoken more loudly than any argument ever could. Several other board members also stepped down. Some quietly left the neighborhood within the following year. Others remained but returned to being ordinary residents. The atmosphere throughout Willow Creek Estates changed almost immediately. For the first time in years, board meetings focused on solving neighborhood problems instead of issuing violation notices. Residents volunteered for committees. Neighbors who had barely spoken to one another began working together on landscaping projects, holiday events, and community improvement programs. The HOA gradually returned to its original purpose, serving homeowners instead of controlling them. Daniel never sought public recognition. When local reporters requested interviews after the settlement, he participated only once. He spoke briefly. He explained that homeowner associations could play an important role in maintaining communities when governed fairly and transparently. He reminded viewers that authority carried responsibility. Rules should protect neighborhoods, not intimidate the people who lived in them. His calm approach resonated far beyond Willow Creek Estates. The story spread across regional news outlets. Legal organizations invited Rebecca Lawson to speak about homeowner rights. Neighborhood associations throughout the state began reviewing their own governance policies. Several communities voluntarily adopted reforms similar to those included in Daniel's settlement. What began as a dispute over a backyard deck had sparked conversations about fairness in neighborhoods across the region. Life slowly returned to normal. Each morning, Daniel continued his familiar routine. Coffee on the back deck. Birds gathering near the white roses Emily had planted years earlier. Sunlight filtering through the old oak tree at the edge of the yard. The deck that had nearly cost him his home now became his favorite place to sit. Not because it represented victory, but because it represented perseverance. One autumn afternoon, nearly a year after the lawsuit concluded, the neighborhood hosted its largest community picnic in decades. Families filled the park. Children played without worry. Neighbors shared homemade food. New residents introduced themselves to longtime homeowners. The sense of community that had nearly disappeared had finally returned. During the event, the newly elected HOA president thanked dozens of volunteers who had helped rebuild trust throughout the neighborhood. Daniel's name was mentioned only briefly. He quietly smiled from the back of the crowd. Recognition had never been his goal. Emily had once believed that a home became valuable not because of its market price, but because of the people who protected one another inside the community. Standing among neighbors who had learned to work together again, Daniel realized how right she had been. As the evening sun settled over Willow Creek Estates, he walked home past children riding bicycles through streets that once felt filled with fear. The white roses continued blooming beneath the front window. The blue mailbox Emily had painted still welcomed every visitor. The rebuilt deck stood strong behind the house, overlooking a backyard filled with memories. It had never truly been about lumber permits or HOA paperwork. It had been about protecting something far more important: the right to feel secure in the home built through years of sacrifice. The responsibility to stand against unfairness, even when standing alone. And the quiet truth that one determined person, armed with patience, evidence, and integrity, can inspire an entire community to rediscover justice. Sometimes the strongest foundations are not built from concrete. They are built from courage.